So what if a friend or loved one passes away owning real estate and you're the personal representative or the executor or the person in charge of the estate? What's the first 4 steps that you can take to ensure that things run a bit more smoothly? First step, folks, that I would recommend would be to collect the will if there is one, and collect a certified copy of the friend or loved one's death certificate. Now, when it comes to the will, it would be the original version of the will, right? You would need that original document to submit to the probate court. Whether you're engaging an attorney or not, you're going to need both of those documents in step 1. Step 2 would be to value the real estate at the time of your friend or loved one's passing. The way that you could do that is if you have a friend that's a realtor or know of a realtor or can engage a realtor from the outside, you can get a market analysis from that person. I'd recommend that the market analysis be in writing because, once again, that's eventually going to be submitted to the court. Or the second way to do this is to engage an appraiser and get a written appraisal done on the piece of real estate. All of this to place a value on the real estate at the time of your friend or loved one's passing. That'd be step 2. Step 3 would be to collect the names, addresses, and telephone numbers of the immediate family or the folks that are going to be involved in the probate in the estate itself as the devisees or the heirs of the estate. And the reason why you want that is eventually you're going to have to submit that information to the court. So that would be step 3. Now, step 4 would be to determine at this point whether the family is going to, or friends are going to, or heirs are going to get along. And the reason why you want to know if there's going to be any dissenters or objectors in the group is if you're filing the probate on your own or you're engaging an attorney. Well, at least in Massachusetts and many other states, there's one of 2 ways that you can submit a petition. It can be formally. When you submit a petition formally, you are asking the court to issue what we call a citation or a notice to all of the devisees or the heirs in the estate, and a judge is appointed to the case. There may be a hearing down the line. This is typically if folks are objecting or dissenting or they're not getting along. They're fighting, in other words. If all of the parties, the heirs, the devisees, are getting along, then the second way that a petition could be filed is informally. And with an informal petition, that means that a magistrate will be appointed and not a judge, and a lot of things can be done administratively with no hearings necessary, saving the estate time and money. So those are the first 4 steps that I can suggest if you come across a situation where you're involved in an estate, handling an estate on behalf of a loved one or friend. Dave Ceruolo, CeruoloLaw.com.